morning, Mr. Slega. Good morning, everybody.
Morning, Chairperson.
Are you ready?
Yes, Chairperson, we are ready. As mentioned yesterday, Chairperson, our witness today is Mr. Brian Molefe. He's appearing for the second time. We were interrupted last time by an unfortunate exposure to COVID, but he's here. Mr. Molefe will be ready to take the oath of affirmation.
Yes, just either place on record or Mr. Masuk can just
Yes.
place on record that he and his team are representing Mr. Molefe.
Correct.
Again. You can do it from there if you are comfortable to do it from there.
Deputy Chief Justice,
Yes.
together with Mr. Tsepe and Skakane, we appear for Mr. Molefe on the instructions of Malaba attorneys.
Thank you. Okay, Mr. Slega.
Yes. The affirmation.
Yes, please administer the oath.
Oh, oath.
Welcome back, Mr. Molefe. Just switch on your mic before you take the oath. Thank you.
Please state your full names for the record.
Brian Molefe.
Do you have any objection to taking the prescribed affirmation?
I have no objection.
Do you affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Thank you. You may be seated.
Thank you, Chairperson. Chairperson, Mr. Molefe's affidavit is found in Eskom Bundle 17. Eskom Bundle 17, and it has been marked as Exhibit U 38.1 on page 5.
Yes, I've got it.
Mr. Molefe, you will have the same bundle in front of you, which contains your affidavit.
And you can keep your mic on at all times, Mr. Molefe. For the benefit of the public, Mr. Sleka, you might wish to just reorientate the public in terms of where
Yes.
we were with Mr. Molefe's evidence when we had to adjourn last time, and what he had dealt with or was still busy dealing with, and what topics he will cover for today.
Yes, thank you, Chairperson. On the previous occasion when Mr. Molefe appeared, we dealt with matters relating to his background, employment at Eskom, relationships with the Guptas, and whether or not there was also a relationship with Mr. Salim Essa. And Mr. Molefe elaborated on in his answers to those questions. And his secondment was also touched upon to some extent, to the extent that he had knowledge of it. What we will mainly be focusing on this time around, Chairperson, is on what we refer to as the transactions. Mr. Molefe deals with that in his affidavit. The prepayment of 1.6 billion rand, which is converted into a guarantee in December 2015. The prepayment of 659 million rand in April 2016 to Tegeta. And we will touch a little bit before the McKinsey matter, the penalty as well. Sorry, the 2.17 billion rand penalty that Eskom sought to impose against OCM. We will refer to the cooperation agreement, Mr. Molefe, that Eskom and OCM had, and the termination thereof that led to the arbitration. So those are the aspects that we intend touching on today.
Okay, that's fine. Another issue which you should look at, or maybe your junior could be looking into, is that I remember that when Mr. Molefe was here last time, in the statement that he made before he started his evidence, he had complained about the commission in respect of certain things. I don't remember all of them, but I do remember that one of the things he had said was that he had written to the commission, I don't know whether in December and or earlier, where he had made it clear that he was very keen to come and give evidence before the
Yes.
commission, and he was wondering why the commission had to issue summons against him. So my recollection is that neither you nor I dealt with some of those issues, and I think it's important that
Yes.
at least some of them should be dealt with,
Yes.
to the extent that your team might not have looked into them. They need to be looked into so that at some stage they can be dealt with.
Yes.
Yeah. So it
The-
doesn't have to, they don't have to be dealt with now, but
Yes.
maybe your junior can go back to the statement and then look at the issues that were not responded to.
Yes.
Yeah. Okay.
The summons one, Chair, I think we did explain it either in a letter or in an email. I think it's a letter. That,
But it's important that because he made his complaints public,
yes,
that the explanation should be public as well.
yes,
Yeah.
yes.
Uh,
Yeah,
As I say, it doesn't have to be done now, but
Yes.
it's got to be done, I think, at some stage today.
yes, no, that's all right.
Yeah.
Can I explain the one of the summons though, Chair?
If you
Because it's a
if you
simple
are
one.
able to, that's fine.
Yeah, it's a simple one. We did explain to Mr. Molefe that a summons is a formal notification that is given to every witness who comes to appear. It's not that it's issued because the witness is resisting to come and appear. It's just that we ensure formally that the date and time for the witness has been communicated, and the witness will do an appearance on that day. So it's not because you're resisting to appear. I know he said he would have come willingly, even a letter or a telephone. So I think we did explain that.
Yeah, well, maybe I can add this. When the commission started in 2018 and in 2019, our attitude was that somebody who is cooperating with the commission, who is willing to appear, shouldn't have a summons issued against them. We should only reserve that for somebody who was not cooperating and so on. And many people who came to give evidence in 2018, 2019, did so without actually being issued with summonses. But there came a time, because of the time constraints left and the time left for the commission to finish its work, when the attitude was sometimes somebody might not be somebody who's not cooperating, but might be putting certain priorities ahead of the commission in terms of dates, to say, well, no, I'm not available on that date, I'm available on another date, and negotiating that is just not the kind of thing that we would do, because then if we do that, it becomes problematic. So we then said, well, if we want you to come to the commission on short notice, we will negotiate dates. But if we are going to give you what we regard as reasonable notice, we won't negotiate, we'll say that's the date. But part of the reason of the change of attitude was to try and make sure that we are guaranteed that the person will appear if we have issued a summons, because if we haven't issued a summons, if something comes up, the person phones and says, can we change the dates and so on, and there are problems with that. So Mr. Selega is right to say, just because a summons is issued against you, it doesn't necessarily mean you are not trusted to cooperate. So we have issued more summonses as we approach the end of the work of the commission than we did when we still had quite a lot of time. Okay, all right. Other issues you will deal with later?
Yes,
Mr.
Chair.
Selega.
Yes,
Okay, all
thank
right.
you. Thank you, Mr. Molefe. Last time you, just remember, I'll be leading your evidence, and I'm not your opponent.
You're not?
I'm not his opponent. So last time you, even as I put people's versions to you, it's merely to get your response, like we did Mr. Hangbester, who testified here previously. So we will carry on along the same lines. Just to recap, you testified about your relationship with the Gupta brothers. I think is it all of them, your visits to their place, and the intention with them, is it with them to form a bank, to establish a bank? And that is way before you came to Eskom, from your explanation. So, and then we also mentioned to you the evidence of Mr. Hank Bester prior to your secondment to Transnet, to Eskom, how Mr. Salim Essa said to him that we will show you how powerful we are, that we have already decided who's going to be the boss at Eskom. And that we were, in that regard, trying to show you that your secondment to Eskom seemed to have been pre-planned. Pre-planned not just by, let me just say, pre-planned by third parties outside of government. You have made your comments on that. And then it was the announcement by the Minister Lynn Brown at the time, on the 17th of April, 2015. Just over a month after Mr. Matuna was suspended, that you will be seconded to Eskom. That's on the 17th of April, 2016, 15, I beg your pardon. There was a meeting on the 23rd of April, 2015, which took place in Cape Town, a meeting of the board. I believe you attended that meeting. Is that correct?
Yes, that is correct. But before we proceed, Chair,
Yes.
just as we are recapping, I just want to remind the Commission that I did make a statement which made a substantive allegation, to the extent that I felt that Glencore had been trying to extort 8 billion out of us, and that the president had been made the current president had been made a shareholder in Optimum, actually, significant company that is at the center of everything that has happened here. I'm saying this now because the fact that while we were recapping, that was not mentioned. I hope that it is not being swept under the carpet and being forgotten conveniently. Just to make sure, Chairperson, that it did register,
Yeah.
and that there is a certain amount of weight that will be attached
Yes.
to what I said, because it is at the center. Glencore and Optimum are at the center of all these files that are behind me.
Well, Mr. Molefe, I'm surprised that you would think that it's being swept under the carpet, because you said it publicly. And you know from your own experience that when a witness says something that implicates somebody in terms of the rules of the commission, that person is given a copy of that statement so that they have a chance to respond. So I didn't expect you to think that it would be swept under the carpet. I know some media said your evidence was stopped because you made allegations against the president, so the commission.
No, I was just concerned that it is not being mentioned as we are recapping.
No, we didn't mention everything. I'm sure, certainly, I don't think we mentioned everything. The only thing I wanted to mention was something that was not responded to, which you said. That's what I wanted to raise.
Thank you,
But I do know, I have been told that your statement that you made on that day, which you handed up, was sent to people who were implicated in it. So there is nothing that is being swept under the carpet.
Thank you, Chair.
Yeah.
Yes, I was at the meeting.
Thank you. We did exchange that, Chairperson. Yes, in that meeting, Mr. Molefe, there was the issue of the cooperation agreement between Eskom and OCM. That cooperation agreement dated back to March or May 2014, in terms of which, and it was the culmination of negotiations between the parties about coal qualities, amount of coal to be supplied, and it culminated into that agreement, which was intended to ultimately amend the existing coal supply agreement between Eskom and OCM. The item was on the agenda at the board meeting of the 23rd. Having it been referred to the board by the BTC that set on the 15th of April, 2015. When you look at the minutes of the meeting, it says that the item had to be removed, should be removed from the agenda. And the board members have come here and said, that item was referred to you with certain instructions. Can you give the chairperson your recollection of what transpired in that meeting in respect of that item, of the cooperation agreement and the intended fourth addendum to the agreement between OCM and Eskom?
Yes, Chairperson, that agreement was referred to me.
Sorry?
It was referred to me, as you correctly point out.
Oh,
today.
okay.
Well, I think you may have to be specific, Mr. Seleka, if you want specific information. Do you want to find out why it was referred to him? Or,
Yeah, then I will follow up. If he says, yes, it was referred to him, I can follow up then.
yeah.
Yeah. Yes, Mr. Molefe, can you recall why it was referred to you?
I would imagine because I was the acting group chief executive, and the board felt it appropriate that I should deal with it.
Yeah.
Sorry, Chair, I'm sorry to interject. I'm not sure whether it's the acoustic are a bit bad. I'm struggling to hear. I'm struggling to hear actually all of you.
I'm sorry, I
I'm
think,
struggling to hear all of you. I'm not sure whether there is a volume somewhere.
or you
that
can't
needs to be
hear
up.
us,
Yes.
or even with me, with my voice.
No, well, I don't have a problem with your voice. I actually like it. But
Yes, okay, but I might have to raise it because there have been times when people say they can't hear me, so I've
Yeah.
always assumed I've got a loud voice, so. But Mr. Selega, I have to remind
But
him now and
especially
again.
Mr. Slega, yes.
I
He's got a
have
very
to
soft
remind
voice.
him to speak up because he has a very soft voice. So let's try, and if the problem persists, just alert me again. So if there is anything that the technicians can do to assist, they must do that as well. Okay, you'll try and speak up, Mr. Selega.
Yeah. Chair, I think it was the sound system this time around.
Yes, I must say also, I think you should try the same, Mr. Molefe. You also should also try and speak up a bit.
I will do so,
Well,
Chair.
yeah, okay.
Yeah. Mr. Molefe, I'll refer to documents insofar as you need me to, always necessary. So that meeting, what the board members have said, the matter was referred to you with the instruction that you will get information and come back to report back. They say, and from the evidence that we see, is that in June 2015, you terminated the cooperation agreement and the negotiation process. And they were not aware that the termination had taken place. You did not come back to them prior to you doing the termination. And that's why I was asking you, can you tell the chairperson your recollection of why the matter came to you? But now can you comment on what the board members have said here? About you having been given explicit instructions to come back, get information, come back, but they say you went ahead and terminated without them knowing.
Chair, you know, a lot has been said about the fact that I refused to negotiate. That is not true. We negotiated. We spoke.
I'm sorry, just repeat that.
A lot has been said about the fact that we refused to negotiate.
Yes,
We did not refuse to negotiate. We negotiated. As evidence of the negotiation, I think even in Mr. Bester's affidavit, he says that.
I'm sorry, Mr. Molefe. Maybe just so that we follow the sequence, let's start with, is it true that when the board referred that matter or that proposed agreement to you, they asked you to come back to them and report back? Let's start with that. Then later on.
My understanding at the time, Chair, was that I should deal with the matter
As you saw fit,
as I saw fit and then report to the board about how it was dealt with.
about the progress or whatever?
Yes, about whatever has happened to
Yes.
us. Yes.
Oh, okay, all right.
That was my understanding. It
Okay.
was not just a matter of going to find out what was happening,
Yes.
because that would have taken me a day or two to find out
Yeah.
what was happening.
Yeah.
So it was not just an instruction of go and familiarize yourself.
Yeah, okay.
It was deal with the matter and report back to us about how you have dealt with it.
Okay,
Yes.
okay. Okay, then I think you can deal with the question of negotiations because I think you were introducing that in the context of what Mr. Selega says has been said by board members, namely that you terminated the agreement without
Yes.
coming back to them. I think you want to say before you terminated, there were negotiations or whatever.
Yes.
To deal with it.
Yes.
Yeah. I'm going to read from the minutes in the light of that explanation, Mr. Molefe, which is, the minute is in, you get EB, Eskom Bundle 18.
Yes.
Is Eskom Bundle 18A. Page 416.29.
Okay, I think go ahead and read because we
Yeah.
might be able to manage
Yes.
without checking, but Mr. Molefe must feel free to check.
Yeah. In regard to this item, they say it was requested that the submission should be taken off the agenda and submitted to the acting CE before being tabled for approval. And then the resolution says, resolved that the referral from the BTC for approval of the mandate to conclude negotiations with Optimum Coal Mine for coal supply to Hendrina Power Station is not approved, and two, the mandate should be referred to the acting chief executive before being tabled at board for approval. So the mandate specifically related to the negotiations with OCM. You recall that?
The mandate was to deal with the fact that OCM wanted an increase from 150 to 530, as I understood it at the time.
Yes. So the mandate to the team was to negotiate with OCM and then come back.
Did it say negotiate in there, in the minutes? I wasn't able to get to the page.
Oh, yeah.
But I mean, you have also referred to an agreement that was there.
Yes, the cooperation agreement.
So I don't know what the understanding is in terms of, was it to negotiate the agreement or what was it about? I mean, in your understanding, because my understanding was that I should go and deal with the matter, the substantive matter of what was being sought by OCM.
Yeah. What had happened here is that the BTC had taken a decision for Eskom team to negotiate with OCM the possible terms for the amendment of the then existing coal supply agreement. So pursuant to those negotiations, there was a cooperation agreement, and this is just for the parties to cooperate with each other, negotiate, in pursuance to the amendment of the CSA, the coal supply agreement. That mandate produced a report to the BTC which is what we are talking about. These are the proposed terms to increase the price from 150 to 442 rand. BTC did not approve the mandate. It referred it, or the submission, it referred it to the board. The board then here, on the 23rd of April 2015, says the mandate is referred to you before it being tabled at board for approval. So when you read the minute, the board envisages that that mandate will come back to it for approval. And I want you to explain what the apparent, you can see the apparent inconsistency or discrepancy between the minute and your explanation about your understanding of how the matter was given to you to deal
So
with.
you are saying that the board was referring the matter to me to just rubber stamp it?
I don't know. The board said,
and endorse what, in your opinion, was an outcome that had already been predetermined, that the price would be increased. No, that
No.
was not my understanding. My understanding was that I was not being instructed to rubber stamp anything. In fact, because I was a new CEO,
can I say
I
something?
cast a new eye
Can-
onto the whole matter.
May I say
In
something
total.
before you proceed? May I say something before you proceed? I'm not saying anything. I have no opinion on it. All I'm conveying to you is the evidence of the board members. Mr. Paminsky came here and said so. Ms. Viroshni Naidu came here and said so. Ms. Venita Klein said so. That this matter was given to you to get information because they couldn't get answers from the team that was handling the matter. And they gave it to you, get feedback, and come back to them. It's not me.
No, and I'm saying to you, Mr. Sileke, that
Yes.
the mandate was not to get feedback. The mandate was to deal with the matter. I mean, getting feedback as an instruction from the board to a CEO, just go and get feedback. I mean, that is a clerical function to get feedback. I was a group chief executive. I had to look at the matter and deal with it decisively, which is what I did. But to add, Mr. Sileke,
Tell the chair.
the agreement, Chairperson, the agreement that you refer to, I subsequently discovered, had been signed by an official who did not have authority to do so in the first place. We don't know who that official was working for that had agreed to this proposal being brought to where it was. We did not have, we did not know who the official had been working for. The agreement had never been to the board before it was signed. The implications, the financial implications were such that the size of the transaction that was being proposed to be done was so big that that official did not have authority. If you question Mr. Koko, the official that signed the agreement reported to Mr. Koko. Mr. Koko was not even aware at the time that the agreement was being signed. So I even suspect that it may have been ultra virus, that it is an agreement that was not supposed to have gone to the board in the first place. So the way that I dealt with it, I looked at it objectively, and I found it to be preposterous and unacceptable.
So if we take it step by step, what do you say about the minute as recorded here, that the mandate is referred to you before being tabled at board for approval? Because clearly then, the minute contemplated that the matter would come back to the board for its approval.
Chairperson, what I'm trying to say is, my understanding as the group chief executive was the board, I don't know how, well, the minute maybe have been worded the way it is worded. But my understanding was that it was a substantive instruction to deal with the matter, irrespective of how the minute is minuted. My understanding was the board would not come to me and say, go and find out what happened here and come back and report to us. The mandate was, so the dynamic interpretation, not the literal interpretation of those words that are in the minute. The dynamic interpretation that I gave to the minute was deal with the matter as a chief executive in the interest of Eskom, which is what I did, which is what was the subject, actually, of my entire statement when I came here for the first time.
Yes. So we are to understand you to be saying the minute is what it is, but your understanding was different.
No, my understanding is dynamic. It's not literal. And there's a big difference between
No,
that.
no, Mr. Molefe, you and Mr. Selega agree.
Yes,
You are not saying you are disputing
yes,
what is written in the minutes.
yes.
You just say you have your own interpretation of what the minutes mean.
Yes, Chairperson.
Yeah, so that you are all, there is no dispute on that.
Okay.
There is a dispute, there may be a dispute in terms of the board members' understanding of what was decided, their understanding and his understanding. But as I understand it, he certainly is not disputing that that's what the minutes say. But he says his understanding was that he was to deal with the matter as he saw fit as Group CEO. And to report simply what he had done to deal with it. Mr. Molefe, is that correct?
That is correct, sir.
Yeah, that's what he is saying. It may be that the board's or the relevant members of the board's version might be different from his understanding, but that's what he says his understanding was.
Yes. So on that understanding, before you made any final decision, you didn't take the matter back to the board for its approval.
Chair, I did not make any final decision.
Is the termination of the cooperation agreement and negotiation process.
As I said, I even suspected that the cooperation agreement was ultra vires. Secondly, there was nothing to negotiate. What Optimum was putting on the table was preposterous and illegal because
Yes.
we had an existing agreement that they would pay us 150 rand for coal until 2018. To vary that to the disadvantage of Eskom would have required me to break provisions of the PFA.
Yes. But I'm asking a simple question, which is, even as you perceived of those factors, and you decided that I'm not proceeding on the basis of these proposed terms, these are preposterous, and you bring that to an end, when you made that decision, prior to making that decision, did you take the matter back to the board for approval? You didn't take the matter back to the board for approval. That's all I want to know.
No, Chair, there is no recorded decision that I made to terminate discussions or to stop negotiations. There is no recorded decision like that I
Yes,
made.
is there an unrecorded decision?
There is also no unrecorded decision. What simply happened?
So did the negotiations end by themselves?
No, they didn't end.
They
They
went
didn't
on.
end. The process of negotiation, Chair, is ongoing, and people employ different negotiating tactics.
But you can't negotiate forever.
We can't negotiate forever.
So somewhere you can use different strategies to bring finality, but in the end there must be some finality.
There must be some finality.
Yes, yes.
In this instance, the finality, if the negotiations were continuing forever to the disadvantage of Optimum, they had the option of taking it to arbitration. That is what they were supposed to do. So
Of course, when between the two parties, one of the parties took an issue that was the subject of negotiations for some time, took it to arbitration, that would mean the negotiations end because now you go to a compulsory route to fight it out.
Yes.
Yes, yes, yes.
So it was not for me to take the issue on arbitration because I had a contract
Yeah,
for 150 rand until 2018. I had no dispute. So Optimum would have gone to arbitration. By the way, Chairperson, a date for arbitration had been set. They actually, I think they
and they
went.
did not pursue it.
They
And they
did not
did not
pursue it.
pursue arbitration.
They did not pursue it. Before the date arrived, they then went for business rescue.
Yes.
So the date in Mr. Efron's affidavit, he refers to the fact that there was a date that had been set for arbitration.
You said earlier on to change the agreement would have been illegal, and you referred to the PFMA.
Yes.
Why would it have been illegal for two parties to an agreement if they were satisfied that they should amend one or more of the clauses in the agreement for them to agree? We agreed to amend this. Why would that have been illegal?
If both parties were satisfied.
Yes, obviously you can only amend an agreement if both parties agree.
Yeah.
You can't amend it unilaterally. Nobody can do that.
Well, only one party was satisfied in this case.
No. What I'm saying is you had OCM
Yes.
that wanted
Increase.
an increase. And you had Eskom who were happy with the status quo, okay, in terms of the price, the agreement.
Yes.
Yeah. And OCM initiated, as I understand, discussions and negotiations to say, could we relook at the price and made whatever demands it made? So the point I'm making is they were seeking an amendment of the agreement.
Yes.
And an amendment can only happen if both parties agree.
Yes.
So I was just saying, why would it be illegal if both parties agree? Or that's not what you meant?
Yeah, I'm just saying that I did not agree. So both
Yeah,
parties were not
okay.
in agreement.
Okay, but if
But
Eskom,
the other issue, Chairperson, is the
hang on
bona
one
fide.
second, just so that we finalize this. If Eskom was persuaded to increase the price by whatever, and there was agreement, there would be nothing illegal as far as you know.
Yes,
Yeah,
yes.
okay.
If both parties had agreed
Yes, yeah.
to amend the
Yes,
yeah,
yeah.
that would have been fine.
Yes, okay.
However, Chairperson, here, motive and bona fides, the Optimum were in the position that they were in because in 2012, when they bought the company, they did not do due diligence. My feeling was, here we are Eskom, we are in financial difficulty, we are load shedding. The company is literally collapsing because when I arrived at Eskom, there was talk that we won't be able to pay salaries in 3 months. We are literally collapsing. These people made a mistake 4 or 5 years ago. Perhaps it was not a mistake. And that was the whole point of my statement. Perhaps it was not a mistake. Perhaps they had banked on something that is contrary to good moral to get them this agreement. The fact that there are people inside Eskom that had signed that agreement ostensibly without authority also made me suspicious that there are people inside Eskom that are pursuing a particular agenda to satisfy these people. I was just uncomfortable with it. Chairperson, I have a feeling that if I had signed that agreement or agreed to OCM's request, we would be sitting in this commission or a similar commission where you would be asking me, but Mr. Molefe, if you had an agreement for 150. What was it that drove you to agree to this ridiculous increase that has now collapsed Eskom? So I had to do, Chairperson, what I believed was correct. And the background information that I knew did also not smell good, which is why I was at pains to make the statement that I did when I came here.
Well, you were speaking earlier about things being swept under the carpet, and I said to you that people implicated in your statement, as far as I know, have been given your statement so that they respond. One of them is Mr. Efron, I think, and he has, as far as I know, he has filed an affidavit in response to your statement. So the commission has been looking at that, and I think probably Mr. Efron might come back and deal with certain matters. So I just remembered that Mr. Efron has actually filed an affidavit in response to your statement.
But, Chairperson, this strategy had gone beyond Mr. Efron.
Yeah.
Mr. Glazenberg came to see me about this. And it was Mr. Glazenberg that had a very good relationship with the chairperson of Optima before he became deputy president. So Mr. Efron will come and give you a technical answer. But my feeling was that at the very high level, at the level of the chairperson of chairperson to chairperson, Mr. Efron was the CEO of Optima. He was, in the greater scheme of things, in what I suspect was happening, a little less significant than the people at the top. Perhaps what you need to do, Chairperson, is to ask Mr. Glazenberg if he has any comment.
Well, the legal team may look at that, but I am aware that the commission had been in touch with Mr. Glazenberg's attorneys at some stage for him to provide certain affidavit which he provided, but because he lives abroad, there may have been challenges at the time about him coming here, but the legal team will look at the matters and take it from there. But Mr. Efron has certainly filed an affidavit in response to your statement, and he might well be called. We do have time constraints, but he may be called. And if you have not been given that affidavit, it should be sent to you for you to see what he says.
Chairperson, can I add something? If I may. It may be a long-winded story again. It may be a long-winded story again.
Okay, let's hope not.
Yes.
No, want to finish.
When I was at Transnet, Chairperson, when we bought the 100 locomotives,
And you?
we bought the 100 locomotives. It was because Transnet had not been giving a good service to the coal industry to transport their coal to Richards Bay. So we went and we decided that we're going to end their pain by buying locomotives, because the locomotives on that line were very old, 40-year, 50-year-old locomotives, and they were breaking and unreliable. So, but then we then said to the coal industry, we will buy the locomotives at huge expense to Transnet, but you guys must agree that we will sign take-or-pay agreements. When the take-or-pay agreements are signed, it means that when the locomotive arrives at your mine, you can't tell us that you don't have coal that needs to go to Richards Bay. If you don't have the coal to go to Richards Bay, you will pay for that locomotive, because we need to pay back the money that we are borrowing to buy the locomotive. The entire industry agreed, except one company, Optimum, in 2014. They refused to sign the take-or-pay agreement. Until one day when I got a report from Mr. Gama that Optimum is the only one that's refusing to sign the take-or-pay agreement. I said to Mr. Gama, please call Mr. Efron and tell him that we're coming to his office now. He said it's not convenient. I said it's fine. We are okay with it. And we went to his office there and there. And I arrived there and I told him, Mr. Efron, that Mr. Efron, if you don't sign this take-or-pay agreement when the entire industry has signed the take-or-pay agreement, we will not give you trains. It's as simple as that. Mr. Efron's response was, no, Mr. Molefe, we are waiting on Eskom to sign certain agreements with us. When those agreements are signed, we will be happy to sign your take-or-pay agreement. Chairperson, I said to him, I'm not interested in Eskom. I'm not interested in... the fact of the matter is that if you don't sign in the next 24 hours, you will not get trains from us because the whole industry has signed. Mr. Efron reluctantly signed within 24 months. That was March 2015.
You mean within 24 hours?
Of
said-
our meeting.
Yeah, I thought you said within 24 months, but maybe I
24
didn't hear.
hours, yeah,
Yeah.
he signed. He signed the agreement. That was March 2015. Guess what, Chairperson? Unbeknown to him and to myself, I'm then seconded to go and become Group Chief Executive of Eskom. A month later, literally. And when I arrived there, here's Mr. Efron with the agreement that he's waiting for. And that agreement is basically extorting. And I felt that, Optimum said to us they won't sign take-or-pay agreements because they're waiting for an agreement. Meantime, this is the agreement that they're waiting for. So that is a bit of background, Chairperson, to explain my frame of mind when I dealt with the Optimum matter. It's because perhaps I knew too much. I knew that on the other side, they were trying to play us using Eskom's name. Perhaps at Eskom, they were also playing Eskom using Transnet's name. But unfortunately, I crossed the line and I saw both sides of the coin, and I did not like it, Chairperson. And I felt that Optimum could not be allowed to behave like that, especially because they probably feel that they have a very good relationship with the then Deputy President.
With you?
With the then Deputy President.
Yes.
Yes.
Well,
That is the background.
I guess at the time you asked, or he was Deputy President at the time, 2015?
Yes, it was 2015.
Okay, all right. Yes. Mr. Selega?
Chair, I'm contemplating, Mr. Molefe, approaching the matter differently. I will read from...
Excuse me. I would like us to move with some speed
Yes.
because so far we have only dealt with what the instruction of the board was to Mr. Molefe on the 23rd of April 2015.
Yes.
So I think we have got to try and move with some speed. I know that there probably is no single person who is holding us back, but Can I ask you to move with some speed?
Yes, Chair.
Yeah.
Mr. Molefe, let me do this. Let me paint a picture here of what one sees from the evidence. Please have Eskom bundle 18 in front of you. It's 18 bracket A. Bracket A, please turn to page 383, and I'm referring to the black pagination on the top left-hand corner. Page 383. Yeah. So what we see from the evidence, firstly, this is a submission document to the board tender committee. So it's firstly to Eskom Procurement Subcommittee, 25 March 2015, and then the Board Tender Committee, 15 April 2015. And the title of the submission is Mandate to Conclude Negotiations with Optimum Coal Mine for Coal Supply to Hendrina Power Station. The resolution required, the Board of Directors Tender Committee resolves that Primary Energy Division is mandated to conclude negotiations with Optimum Coal to ensure security of supply for Hendrina Power Station at 442 Rand. February 2015 money values, or a CV, and it goes on. 2.2 says PED, which is Primary Energy, is mandated to negotiate and conclude the termination of the optimum hardship claim in lieu of writing off penalties that have been suspended against Optimum.
So that was a request from the
this
PED
is,
to the board.
that's right.
Yes.
Then you go to page 390. 390. It's a document titled Approval of a Negotiated Outcome, compiled by Mr. Johan Vester, Primary Energy, and then again, serving before the Eskom Procurement Subcommittee, 25 March 2015, the BTC, 15 April 2015, and the description is mandate to conclude negotiations with Optimum Coal Mine for coal supply to Hendrina Power Station. Then you see paragraph under introduction, the first paragraph under introduction says, Optimum Coal Mine is currently losing money on every ton of coal it sells to Eskom, as well as to export market. Optimum have therefore already initiated the Section 189 process to retrench 1,300 miners and to close the export business by 31 March 2015. Optimum have agreed to continue to supply Eskom on condition that Eskom agrees to pay a higher price from 1 April 2015, which as a minimum will cover the current cost to produce coal for Eskom. Alternatively, Optimum will declare bankruptcy, stop supply to Eskom, and will close the mine in a matter of months. The next paragraph, and I'll read that only, in accordance with the mandate approved by the Board of Directors Tender Committee, BTC meeting 12 August 2014, to negotiate but not conclude coal supply agreements for up to 24 years to ensure the security of coal supply to Hendrina Power Station, this report reflects the progress to date thereof and requests noting of the feedback and a mandate to conclude negotiations with Optimum to ensure security of supply for Hendrina is requested. So that gives you the background to what was happening in regard to the cooperation agreement. The cooperation agreement itself, which I think you need to clarify to the chairperson, because when he was asking about which agreement is, you said is ultra vires, which is signed by a person who doesn't have the authority to do so. I think you were referring to the cooperation agreement as opposed to the coal supply agreement.
Yes,
Is that correct?
yes, that's correct.
Yes.
But before
That-
you proceed, who signed this document?
Who signed?
Who compiled this document?
The compiler. Let's see the first one I refer to. The submission document itself. I don't know whether you can recognize the signatures there. On page 387, there's Group Executive, Acting, Group Technology and Commercial. I think that's Mr. Edwin Mabelani.
It was compiled by Mr. Bester.
Yes.
At the top, that signature looks like Mr. Bester's.
Yes. Certainly, the approval of a negotiated outcome, the compiler is identified as Mr. Johan Bester. And it was signed on page 401 by Mr. Johan Bester, Mr. Vusi Mboweni, and Mr. Edwin Mabelani, the Group Executive Acting, Group Technology and Commercial. The cooperation agreement is on page 377 of the same bundle. And it runs up to page 382. It was signed on the 23rd of May 2014. And on behalf of Eskom, the name there appears to be, is it Kiran Maharaj,
Yes,
Divisional Executive?
yes.
Yeah, 23 May 2014.
Yes,
And the intention was a new agreement would then be negotiated and concluded by the beginning of 2015.
yeah.
Yeah. Now, that is the background. This is the Hendrina Power Station. What that document will show, the approval of a negotiated outcome, is that Eskom had engaged the services of experts. They engaged Nedbank and Basis Points to do an assessment of OCM's financial position. And the proposed amount of 442 rand came about as a result of that expert assessment. And that was contained in this report of April 2015. I should also add this, by the way, that when you read the affidavit of CDH, the attorneys for Eskom at the time, CDH says it was briefed by Eskom to assist in the conclusion of the cooperation agreement. So Eskom had lawyers assisting it to conclude that cooperation agreement of the 23rd of May, 2015. The parties are negotiating. As a result of it, the proposed increases are made based on expect assessment by Nedbank and basis points. You come in, the negotiations are not completed. You come in April 2015. You continue with the negotiations. They're trying to meet with you. You know, Mr. Marsden and Mr. Efron have said it was difficult at first, and they ultimately get to meet with you. And that you played, you took a hard stance in regard to negotiations. Ultimately, you decide to sign a letter, which is dated the 10th of June, 2015, terminating the negotiation process. That letter was apparently only transmitted to OCM on the 20th of June, 2015. So the process is terminated to negotiate. You have this report from experts who are supporting the increase of 442 rand because Optimum is running at a loss. In August 2015, you get a letter. Now OCM is under business rescue. You get a letter from business rescue practitioners. 20 August, they say, we are stopping the obligation to supply Eskom with coal. But they also make an offer for an interim arrangement to supply coal to OCM, to Eskom. The response to that offer was a meeting, amongst other things, was a meeting on the 3rd of September 2015 between you and Mr. Efron. You and Mr. Koko on the one hand, and Mr. Efron on the other. In that meeting, the interim arrangement is agreed upon. 3 September 2015, that OCM will continue to supply coal to Eskom. That interim arrangement subsisted until 29 July 2016.
Mr. Seleka,
Yes, Chair.
if you are going to ask him to comment on all of these things that you have been mentioning, I suspect he might have forgotten some of them by the time you give him the opportunity to.
Yeah.
So I think you might have to ask him some questions.
Yes.
Or if he wants to dispute some of the things we have said, by the time you give him a chance, he might not have recalled, he might not recall what you said 7 minutes ago.
Yes.
So I think if you want him to confirm anything, you need to say what you understand it to be, ask him to confirm and move on to the next one.
Thank you, Chair.
So he has a chance to dispute it while he remembers if he disputes it, or if he confirms, he confirms.
Thank you, Chair. Yeah.
Well,
Mr.
what
Molefe.
you may ask him, Mr. Molefe, you have listened to Mr. Seleka up to now. Is there anything you dispute in terms of what he has said?
I must thank Mr. Seleka for his lecture.
Sorry?
For?
for his lecture on what transpired here.
Yes, but I just want to know whether there is, if you say, look, there's
Chairperson-
nothing of importance that I dispute, then we know.
Mr. Selege's reality is very different to mine. And although we are talking about the same fact,
The
the,
same?
the interpretation of what was happening is very different.
Yes.
Yes.
It's fine, and I'm going to give you a
because
chance.
you are taking this fact and driving a particular narrative, ignoring what I had already put forward in the commission, that what was in fact happening was something else. For example, you go on about the fact that Optimum was in financial difficulty. The biggest problem that I had with Mr. Bester and his memos is that they went on about Optimum and not Eskom. My fiduciary duty was not to Optimum. I had no responsibility to keep Optimum out of bankruptcy. And in the process, get Eskom into bankruptcy, a company that I had primary responsibility to. I think your analysis ignores that. Had you been in my position, Mr. Selege, you might have appreciated the fact that if you do what these memos from Mr. Bester and company are saying we should do, we would have bankrupted Eskom. It's as simple as that. We might have saved Optimum, but we would have bankrupted Eskom. The reason people felt that it was okay to bankrupt Eskom was because they thought that Eskom will get money from the fiscus. The debate was on these matters was, do you bankrupt Eskom or Optimum?
Yes, but what
And they were saying that, well, we as the parent company of Optimum cannot afford to keep subsidizing it, implying that our parent company, which is the Republic of South Africa, could afford continuing to subsidize Eskom, which I disagreed with.
Yeah.
I had been a treasury official,
Yeah.
and I know that we could not, the fiscus could not afford continuing to subsidize Eskom because of mistakes, because of people who did not do due diligence when they bought a company.
Yes.
So Mr. Bester goes on and on and on and on about Optimum's difficulties. He does not talk about our own difficulties. He does not talk about the difficulties of the company that he worked for, and that we could not afford all of this. When you say basis points and Netbank said that they did an affordability test. Did they do an affordability test for Eskom? No.
Yes.
Why?
Can I say something?
Who were they working for?
Yeah, let me just say something, because what I'm trying to do is not to express my view or try to postulate a particular narrative. What I'm trying to do for the purposes of the evidence and for the purposes of the chairperson is to look at the sequence of events prior to giving you the opportunity to then express your comment on the underlying issues. So it's really just to get a sequence of events so that we can see what happened from this date to the next date and the last date. Then you can say exactly what you're saying. Well, this was my attitude in regard to these things.
Yes, but I have said...
1 second. That's where I was saying, take them in small bits,
Yes, Chair.
bits and pieces.
Yeah.
Do you agree that on such and such a date, there was a meeting between so and so where the following was decided? Do you agree that the next thing that happened that was the following? Then let him go with you. Where he doesn't agree.
Yes.
But you are entitled to test the validity of his propositions. You are entitled to test the soundness of his approach. So it mustn't be like you are not going to test that.
Yes.
Just like you should test the propositions of Glencore, Mr. Efron, if and when he comes here. So that should remain. You know,
Yes.
where you feel this needs to be tested, you must test it.
Yes.
Mr. Molefe, it's not as if he ignores what you have said. You were saying that he is following a certain approach, ignoring what you have already said. He's not necessarily ignoring that, because his job entails looking at exactly what happened and why different role players acted in a certain way. And at the end of the day, then we look at everything and make a final. So he's not ignoring it. It's just that for now, he may be looking at a certain issue. Okay, all right. Let's continue.
Yes.
Can we for a sec?
Well, I see we have gone past the tea break. You wanted to say something, Mr. Molefe?
No, I was saying that, for example, this agreement,
The cooperation.
the cooperation agreement. If we look at it objectively, Chairperson, as a person who was in my position at the time, first question is it to Eskom's advantage? Second question is, who signed this agreement? Did they have authority to sign it? Why did they sign it? Why did they sign it? The answers to those four questions were not satisfactory to me as the chief executive. The answer to those questions did not convince me that we are acting in Eskom's interest.
No, that's fine. You have to put your version and your perspective on the issues as you see them, and don't necessarily expect that you will leave the room knowing whether we agree with you or not. You just put your version, your perspectives, and the question of ultimately what is true and what is well-grounded will come later. But from your side, just make sure that you put your version, you share with me how you saw things and why you did what you did. And if you think when you look at my face, it's like I don't accept what you are saying, don't be concerned about it, or if you think I'm accepting it, as long as you put your side of the story, because ultimately I will look at everything when everybody has testified. So, but I think we must take the tea break, and when we come back, we will resume, and let's try and move with speed. Yeah. Okay. We will adjourn. It's 25 to 12. We will resume at 10 to 12. We adjourn.
Thank you.
Okay, let's continue.
Thank you, Chairperson.
Try and allocate some time to each topic so that we try
Yes.
and finish each topic within the time allocated.
Yeah.
Obviously, as you do so, we must make sure that we nevertheless do justice to the issues. Yeah.
Yes, thank you, Chair. I was speaking to Mr. Molefe and his legal representatives. We were trying to see how we can expedite this. Mr. Molefe and I know the facts, more or less, but beyond us, nobody might know the facts. So one is caught between,
No,
But let's
you
see.
can confirm the facts by
yeah,
putting to him what the facts are, and he will say
Yes.
if he agrees or doesn't agree.
yes,
But you would know from his affidavit also what he has no issues with.
yes. yes,
Yeah.
Chair. So thank you, Chair. Mr. Molefe, just that sequence of events again. I mean, I've gone through your coming at Eskom, the termination that takes place on the or the letter is communicated on the 20th of June 2015. Just on the sequence, not your perspective on things, because I want us to deal with the sequence, agree on it, and then we can deal with your perspective, your reasons why you did what you did. Does that bring back memory to you of how things happened chronologically? So the 20th is the termination, 20th of June 2015 is the termination of the negotiation process by letter from CDH. You agree with that?
Chairperson, do you have a copy of the letter?
I have. We'll find it in CDH.
While you may want to look at the letter for maybe purposes of the content, does the date more or less appear to be the date for the termination to you?
My recollection, Chairperson, is that what was happening at the time,
Yeah.
Optimum was employing negotiation tactics. They were very tactical. And they were driving the fear of God into us and saying, you're going to load shed. You're going to have a disaster. That was a negotiation tactic. We, in turn, employed negotiation tactics to counter
Yes.
them.
Yes.
So, I mean, what do you see as something happening does not necessarily mean that what you see is not what you actually see. There was a lot of meaning behind everything that was happening.
Well, you look for the letter, Mr. Seleka, but I think you may have to tackle, if that's what you want to do, Mr. Molefe's evidence about the approach. Yes. Because he said also earlier on that in terms of facts, there might not be much in dispute in terms of what you said. But it's the perspectives or the interpretation of those facts to say, what do they mean?
Okay.
He has a certain interpretation.
Yes.
So you might have to just tackle that head on. You know that I said I had found it strange that Glencore had signed or taken over an agreement with a price that was not going to change for so long. You know, that's the due diligence issue. You know, and I know that Mr. Ephraim does deal with it in his affidavit. But he is saying I was given this, the instructions to deal with this. I looked at this agreement. I took the view that it was in the best interest of Eskom that there should be no amendment of the agreement in terms of increasing the price. He gave the reasons last time. He repeated some of the reasons why he took that view. We know that Glencore or OCM had taken the view that there was a hardship clause, and then they should invoke that if negotiations did not succeed. And he's right in saying, in terms of that route, they were free to go to arbitration, and there was a reference of the matter to arbitration, and the date was set. That's what he has said. But Glencore stroke OCM decided not to pursue that. Why didn't they pursue that if they thought that they had a case? He didn't say so, but he implies that. Why didn't they pursue it? Because that was a compulsory process. Eskom would have been forced to take part, whether they liked it or not, in that process. And if OCM won, they would be bound by that outcome. But I know that last time he told me what he had up his ace, up his sleeve. I think it was Mr. Molefe. I hope I'm
No,
not
it wasn't me.
mistaken.
I heard that.
Oh, you did hear it. It was
somebody said
else.
that we would not have honored it. Or something.
Oh,
It was
yeah,
not me.
yeah, it was-
I
it
think
was-
it was
it was
Dr.
somebody else.
Naidu or somebody. Yeah.
I'm sorry to attribute that to you.
No, it was him.
But basically, those are
No, it wasn't me. We've never discussed this before.
he did say. Well, Mr. Molefe, you are under oath. So I think you might need to
Yes.
take him on
Okay.
whether
Yeah.
his approach was the
Yes.
correct approach or was sound or what.
Yes. So, Mr. Molefe, then, well, let's go to this fact, because ultimately, all said and done, the proposal was that we move the price from 150 to 142 rand per ton. And Eskom rejected. Is it Eskom or you who rejected that proposal?
It was Eskom, Chairperson. I was just a functionary.
You were just a functionary.
Yes.
But Eskom had engaged the experts, as I said. They did the assessment in April, net bank and basis points. CDH itself was also instructed to engage experts in September 2015 to again do another assessment of OCM's financial position. When they engaged, CDH itself was involved, Meridian Economics was involved, and SRK Consulting were involved. They gave you a report in November. They also said, you need to financially assist OCM.
Yes.
And what was your view on that?
I had no obligation to agree with them. You say that their opinions were professional opinions. They lacked one simple thing, which drives any CEO, the interest of Eskom. They were absent in all of those reports.
Yes. Then you have Eskom having rejected the
Well, maybe, Mr. Slega, let's come to what was the basis or bases upon which those experts said Eskom should help OCM. Because Mr. Molefe says, I have a basis for the attitude I took.
Yes.
My basis was the interest of Eskom.
Yes.
So in what way did those experts say it would be in the interest of Eskom for Eskom to help OCM? Then let's take it from there. Let's hear what Mr. Molefe has to say about those reasons that they may be giving, if they gave any.
Yes. Mr. Molefe, you would recall that their expert opinions look at both parties, the position of both parties. One was whether OCM was running the mine at a loss. The flip side of that was that if indeed it was running the mine at a loss, it was then impacting on the ability to supply coal to Eskom. So coal supply to Eskom was a consideration relative to Eskom. So they had that in mind as well, which was reflected in the opinion or the memo that was given to Eskom. So on the face of it, it seems that Eskom's position was also taken into account to require what they considered to be a reasonable amount in the increase of the purchase price, which was, as I learned from you, even less than the market-related amount, the 442 rand. So Eskom's position was also looked at. Your comment on that one?
Chairperson, you must understand this. OCM, Optimum, was a cost-plus mine.
Was it?
A cost-plus mine.
Yes. Yeah, don't be too far from the mic so that
Yes.
I can hear you.
So, it had been built with Eskom's capital. It had been built with Eskom's capital to
Just-
supply.
Just go back in one or two sentences to remind us the importance of a cost-plus mine. I know it's been explained to me. I just wanted to refresh my memory because you have just mentioned that.
I think, Chairperson, cost-plus mines was the biggest robbery that has happened in this country. Those cost-plus mines operated like medieval robbers.
Like?
Medieval robbers. Because what happened is, you as Mr. Zondo, Eskom, the coal is discovered in Enrina. Eskom gives you the money to sink the shaft, to mine the coal. And then you get given a 40-year contract to supply Eskom with coal in the power station that is built next door. You don't put in capital. You just get the contract and to operate the mine and give Eskom the coal for 40 years. For 40 years. So, the proviso in the original agreements was that the coal will be Eskom's coal and nobody else's coal that you supply. And then, sometime in the middle of the agreement, in the case of Optimum, they turned around and said, may we please export some of the coal? The better quality coal. May we please export it? Eskom agreed. And they exported the coal. And they made a lot of money from exporting the coal. The problem arose when the international price of coal fell. They then said they are no longer profitable. But the exporting of coal was something that was additional to the original agreement in the first place, that had nothing to do with the original intention of the cost-plus mine, which is to supply Eskom with coal and not the international market. Those cost-plus mines were not built for the international market. They were built for Eskom. That was the original intention. So now, Mr. Chairperson, what you're saying is, or what I'm putting to you is, the hardship that Optimum was experiencing was because of the fall in the international price of coal. And what they were asking was for us to take the knock on the international price of coal, something that they had not hedged. They should have hedged it. They should have hedged it, number one. Number two, they should have done due diligence. And after due diligence, they would have discovered that there is an exposure to the international price of coal. They did not take these two decisions and were now demanding that because they are suffering hardship, because of these factors, we must pay for it. It was unfair, Chairperson. It was unfair. This hardship was self-imposed. When I asked myself, how could these people that are so knowledgeable, whose parent company is listed in Switzerland, who are operating a global leader in the coal industry, how could they take such simplistic decisions? I mean, I put myself in their shoes and said, at the time when I bought the mine, we would have done due diligence. And the due diligence would have told us that we have an open position and an exposure to the coal price. They continued with that situation, despite the fact that they should have known. A reasonable person in their position would have known that you cannot continue being exposed to the price of coal because your profits no longer come from your operation. They come from speculating on the price of coal. So they had speculated on the price of coal when we're now expecting us to pay for it. Alternatively, Chairperson, they knew that they could speculate and make money. And if they lose, they'll be able to negotiate. But to negotiate, what was their key negotiating point? How would they negotiate? They knew. And in my statement, I say that is why they sold shares to Mr. Ramaphosa, in case they need to do this negotiation.
I think the part of the point that Mr. Selega's question, I think, was aimed at, and I want you to just complete that, was to say that the experts that he referred to, and maybe Glencore or OCM, were saying it's not in Eskom's interest for Eskom not to give us an increase on the price. Maybe not as high as we are demanding, but it's not in Eskom's interest to have us operating under this type of hardship, because it may lead to us either, it may have a result where the security of coal is threatened, or where we can't supply coal or whatever. I think that's part of what was being said, and I think this is the chance for you to say, yes, I understand that, or no, I don't understand it, or that has no validity because of A, B, C, D. Deal with that upfront.
No, I think the reasoning was flawed.
Yeah.
Because it looked at the problem at that point. It looked at the problem at that point and not the genesis of the problem. So I had by that time, I had a full picture of what was happening. As I said earlier, I had even been to the other side in Transnet, and I had seen how Optimum had been operating. And their flaw in the flaw in their conclusion was the genesis. That it was not, it would not have been, you see, Chairperson, if we had done that, we would have it would be encouraging very bad behavior if we had let
Yeah.
Optimum get away with this.
Yes, no, but I don't think that your response in saying the flow of that point or that proposition was with the genesis of the problem. Because you could have a genesis of the problem where you could put them at fault. Say when they didn't do due diligence, or they miscalculated by doing ABC or not doing ABCD, but you might be faced with a certain reality at a certain stage. And I think the question is, what do you say about whether, irrespective of the genesis, whether continuing to insist on the price that was in the agreement could lead to a situation where the security of coal was threatened. Because I would imagine that if you were persuaded that Eskom's interests would be jeopardized by insisting on the price that was in the agreement, even if you said they were at fault for not doing due diligence in the first place, you would say, look, let's look at the reality as it is now. How do we protect Eskom's interests? And maybe you would conclude we protect Eskom's interests by not agreeing to 400 or whatever, but maybe to a little more. So that's what I want you to address, to say, was it true that insisting on this price that was on the agreement could pose a threat to coal security to Eskom?
Chairperson, South Africa has 400 years of coal underground. There's no shortage of coal. What there may be a shortage of is human beings to extract that coal and feed Eskom, supply us with electricity. There's actually not even a reason why coal should be expensive for Eskom. We just have a lot of coal that God has given us. God-given coal, mahal, that is underground. Now, what is happening is that people instill fear into Eskom, especially with load shedding and so on, and say, we don't have enough coal, there's going to be a coal cliff, there's a shortage of coal. If you don't do this, you're going to have dire consequences. What was happening at the time, at the same time as this was happening, and Mr. Bester mentions it, but mentions it in a very wrong way and misquotes me. At the same time as we're having these problems at Nrina, in Medupi, Eskom, at the beginning of the building of Medupi, had signed take-or-pay agreements with Exarwa. And those take-or-pay agreements were supposed to commence, I can't remember if it was 2014 or 2015. And Medupi was delayed. There were penalties in the billions that were supposed to be paid. Now, in that instance, Eskom couldn't afford those penalties. Nobody was saying, those people were not prepared to negotiate and say, guys, we have a delay in the delivery of Medupi. Please relax your penalties. They were not even prepared to negotiate. They were playing hardball in Medupi. What I then said at the time was, can we investigate if it is possible for us to pay the penalties or to pay for the coal at Medupi and get it delivered? Because I think Exaro and I may have the parties wrong, but the parties that were involved in Medupi were banking on the fact that they were going to get the penalties for free, because they don't have to mine, they just get paid because they have a contract which is a take or pay. I said, let them deliver the coal. Let us investigate if it will be possible for the coal to be railed from there to somewhere near Henrina and be dumped there, and then we can carry it into Henrina by trucks or whatever. But let it be railed from there and be taken to Henrina if these people are threatening to close down Optimum mine. What Mr. Bester says, I said they must build a railway line. I didn't. I said, let's investigate if it's possible to transport that coal that we are going to pay for without using. So the investigation would have involved checking the quality of the coal to see if it was possible to use it. But I was quite prepared, Chairperson, to look at options, alternative options, to just simply increasing the price for people that had not done due diligence, that had relied on political influence to make sure that that agreement eventually gets signed. It was principle, Chairperson. It was a matter of principle.
I don't, what comes across from what you are saying may not be what you intend to come across. That because of the genesis of the problem, you might have given that maybe more weight than the question of, okay, is there a threat to coal supply security to Eskom if we continue to insist on the price that is in the agreement? Because as I said, my own understanding, and you must tell me if yours is different, is that if what was driving you and if what was paramount to you was the interests of Eskom, then even if they were 100% to blame for the genesis of the problem, if insisting on the price that was in the agreement would pose a serious threat to coal security for Eskom, what would be called for would be for you to adopt an approach to this issue that could see some increase, maybe not necessarily the one they wanted, but some increase in order to mitigate the threat to coal security, because in the end, your primary concern is the interests of Eskom. What do you say to that?
The threat.
In other words, I want to establish whether insisting on this price that was in the agreement could lead to a situation where there was a threat to coal security for Eskom or not, or what was in place to deal with such a threat if it arose.
The threat of coal supply security, Chairperson, was the bogeyman.
As the?
The bogeyman. It was something that was used to put fear into us. It was a cheap negotiating strategy that you won't get coal. As I said, when I opened this, when I started talking now, I said, we have 400 years of coal in the ground. We don't have a coal supply security issue. In fact, the problem has been that we have allowed, the legislative framework has allowed a few white companies to exploit our coal and have excluded the majority of South Africans in that industry. That is coal that is under the ground, that was put by God there. So we have coal. So that was always my point of departure. Anybody who says coal supply security, I say we have 400 years of coal. The question is, how do we get to Henrina? So it's not like there is absence of coal. You know, Chairperson, if you said to me that if these guys don't give us coal, there would be no coal, then I would be afraid. But if Hendrina closes down, the whole of South Africa has coal. We would make a plan. We would have to make a plan. And if we can't make a plan, we're stupid.
Yes, no, see, I think you're starting to address for me what is quite an important issue. You have 400 years of coal underground, but how quickly could coal start to be delivered if OCM stopped? I think that how much time would lapse without you getting coal to replace what OCM was giving Eskom if the situation ended up in them not being able to deliver coal?
Chairperson, as the CEO of Eskom, allowing yourself to be manipulated by the threat of supply of coal is the thing that drives energy costs up in Eskom and leads to high electricity prices. You must never allow that threat, or you must never appear to be fazed by that threat. Mr. Clinton Efron's boss.
Mr. Efron,
No, his boss,
Glesenberg.
Leisenberg, came to Eskom and said to me, Mr. Molefe, if you don't agree to this agreement, there will be no supply of coal and you will have more load shedding. I said to him, Mr. Gleisenberg, if you're putting a gun to my head, I'm going to ask you to shoot. And the meeting ended on that note. And a few weeks later, I don't know if it was coincidence or what it was, Mr. Ramatlhodi suspended their license. He suspended their license, meaning they won't supply us with coal. When I put 1 + 1 together, I thought, how can Mr. Ramatlhodi suspend their license after they've just threatened me that they will stop the supply of coal? Anyway, we went to talk to him, he put it back. And they continued operating. And then they put the company in business rescue. Now, the thing about business rescue is that all agreements can be suspended. That is the first thing that the business rescue practitioners that they appointed did. Within 24 hours, they told us that if we don't agree to the agreement, because their business rescue plan is increasing the price, if we don't agree to the agreement, that the price will increase. They will have to stop supply to Hendrina. And they did. And we didn't back off. We
They
didn't
did
back
stop.
off. Sorry?
Are you saying they did stop supplying?
They did stop the supply of
Yes.
coal.
Yes.
They did stop the supply of coal for a month.
Yes.
We scavenged for coal. We found coal. Hendrina Power Station didn't close down. It happened just after we had stopped load shedding on the 8th of August, 2015. Here we are celebrating that we now have the operations right. And then they stopped the supply of coal to Hendrina, the business rescue practitioner. What we're supposed to do? Panic. What we're supposed to do? Have more load shedding, as Leisenberg had threatened me. But we didn't. We made a plan. For a month, we supplied Hendrina with coal from other small, mainly BE miners around the area. Until in September, Mr. Efron called and said, Mr. Molefe, can we talk again? I said, yes, we can talk. He said, I've just spoken to my superiors. We are prepared to resume supplying you at 150. At 150. I said,
What was the contractual price again? 100 or 150?
150.
150. So,
About 150.
Or 154.
oh, yeah.
Yeah, 153,
Yes.
150.
Yeah.
So you are saying they were prepared to resume supplying coal at the contractual price?
Yes.
Yeah,
At the
okay.
contractual price. They did. They were prepared to supply us at the contractual price. Except Chairperson. Now they threw a curveball. They say, we are selling the mine to the Guptas. We are selling the mine to the Guptas.
They tell you that?
Well, they announced.
They
it,
were
yeah,
they
I don't
announced
know.
publicly.
They were engaged in negotiations. They talked to the Guptas and they sold
Okay.
the mine to the. And this I said in November 2015. That was a master stroke.
That was?
A master stroke. Because they were so angry with us. They were now going to start a campaign to taint us as Gupta people. To taint us as Gupta people. Skirlek, the public protector came up with a report. She did not interview us. She interviewed Mr. Efron. Actually, Mr. Efron went to her, to complain about us. And she instituted that report. There was a media campaign. Chairperson, you'll be surprised what R1 billion can do. A media campaign of note to rubbish us as people who are controlled by the Gupta. Any scrap of evidence that you were next to the Guptas at any point, because I see in this in this commission as well, there is an allegation that I was in an aeroplane that had the Guptas in them that was flying. I was on my way to BRICS meetings, and they happened to be in the same aeroplane. Now things like that emerge. Yeah, plus Lena, you were in the aeroplane with them and so on. Now you forced us to sell the mine to the Gupta. That is what happened, Chairperson. That is why you and I are here today. Because I refused to sign that 150 rand agreement. I refused to be bullied into acting against the interests of Eskom.
So
they sold the mine to the Guptas. I didn't make them sell the mine to the Guptas. They sold the mine to the Guptas of their own accord.
So are you saying you saw their statements that they would stop supplying coal to Eskom if you did not increase the price, and that therefore Eskom would suffer because there would be no coal?
Yes.
You saw it as a cheap negotiating tactic to try and put pressure
Yes.
on Eskom.
Yes.
You were prepared to see whether they would carry out their threat,
Yes.
and to the extent that they carried out for a month or so,
Yes.
you made alternative plans
Yes.
to get coal
Yes.
until they came back to you
Yes.
and said they were prepared to resume supplying coal
Yes.
on the contractual price.
Until they came back with their tail between their legs. Because, Chairperson, that month, and I knew that was a critical month in the negotiation. Whoever batted the eyelid first, it was like poker. Whoever batted the eyelid first loses. If I had gone back to them and said, sorry guys, we really need the coal, we would have paid even more. Out of interest, Chairperson, Eskom is paying about 900 rand today. From that 150. How did that happen?
In respect of which mine?
It is paying Glencore 900 rand for coal on average.
On other mines?
yeah, other mines, I'm not sure if, I'm not sure what's happening to Henrina. I haven't followed it up. But I was reading somewhere that since we left Eskom, the cost of primary energy have gone through the roof. They've gone through the roof, Chairperson. They're unsustainable. Cost of primary energy before I arrived at Eskom were about 17% per annum increase on average for about 10 years. During the 2 years that I was there, the increase in the primary energy cost was 3%.
Was?
3% below inflation. It's because we did not agree to agreements like this one.
So you are saying they threatened us with stopping the supply of coal
Yes,
in order to try and push us to agree to this high increase.
yes,
We were not prepared, we refused, and we were prepared, we had a plan what we would do if they carried out their plans.
right, yes.
And they did carry it out, and we implemented our plan for that month.
And we did not have
And
load shedding.
we are not the ones who went to them to say, please, can you stop your strike, as it were?
Yes.
They are the ones who came back to us and said, we are prepared to resume on the old terms of the agreement.
The phone call came to me as I was boarding an aeroplane to Cape Town at about 5 or 6 in the evening. The phone rang, and it was Mr. Efron, and he said, we would like to talk about the price and the resumption of the coal supply. And I said to him, Mr. Efron, I'm getting into a plane to Cape Town. In fact, the hostess was telling me to switch off my phone. But there is nothing to talk to you until you start resuming operations tomorrow morning, by tomorrow morning at 8 o'clock. If you resume operation tomorrow morning by 8 o'clock at 1:50, maybe we can talk. Yeah. And then when I got to the other side, or maybe the following morning, he called and he said, Mr. Molefe, I'm sorry to disappoint you. We won't resume operations by 8 o'clock, but give us another 24 hours and we will have resumed operations. I said, that's fine. At 1:50, at 1:50, fine. Then we can talk fair. That was negotiations.
Yeah.
Okay.
Mr. Selega?
Thank you, Chair. A couple of things, Mr. Molefe, to place before you.
So before I just go back to this, part of your saying is in negotiations, you have your own, each party has got its own tactics,
Yes.
how to handle negotiations.
All-
And some of them might look like you are taking too much of a risk,
Yes.
but it's a judgment call that you have to make.
Yes.
But if you take risks and you have an appropriate plan, what you will do if the risk materializes,
Yes.
then it's okay, and that's what you say you did.
Yes. In the literature, Chairperson, when I was trained in negotiations, it's called BETNA, Best Alternative to a Negotiated Agreement. BETNA. So when you're in negotiations, what you assess is that if we don't come to an agreement, what will happen? Will it be worse for the opponent or worse for me? You have to assess that and see that if your BETNA, alternative to a negotiated agreement, is better than your opponent's outcome, then you can go all the way because they can't afford the negotiated, the absence of an agreement. Yeah. So it's a tactic to arrive, but hopefully you arrive at the middle ground before.
Yeah.
But to be threatened by something that does not exist, you can't threaten us with coal supply, with 400 years of coal underground. You can't do that.
Yes.
Mr. Selega?
A couple of things to put before To you, Mr. Molefe. In regard to the stoppage of coal supply, I've got a number of them. I'm not taking them in any particular order. In regard to the stoppage of coal supply,
Yeah.
the coal supply was stopped on the 20th of August 2015. 20 August 2015. That's when you got a letter from the business rescue practitioners and they say they can't supply anymore and they gave you a proposal for an interim arrangement. That coal supply only lived for 13 days because the meeting you had with them was on the 3rd of September 2015. So it was not for a month. The stoppage was not for a month. And they say in Mr. Efron in his affidavit, the meeting was actually requested by Eskom.
By?
Eskom. And then he took the offer, called Mr. Molefe, Mr. Koko, Mr. Molefe, but the two of you met with them. But you actually wanted a meeting with the business rescue practitioners. But when the business rescue practitioners were there, you told them not to be part of the meeting, you will only speak to Mr. Efron. So I'm just putting to you Mr. Efron's version. So the stoppage was 13 days, not a month. And the standard stop days at Hendrina was 35 days. So you could operate within 13 days with a stock pile of 35 days. Because then supply was reinstated on the 3rd of September after the meeting where you agreed to an interim arrangement. Your comment on that?
Chairperson, my recollection is not that we asked for a meeting. Mr. Efron did call me, say that they are prepared to resume operations the following day, at 1:50. And I said to him 8 o'clock the following morning. And later on he said 24 hours. It may well be maybe that there are officials that had been making contact, panicking during this period, and making contact with the business rescue practitioners and Optimum that I did not know about. But I was certainly not involved in going to cap in hand to Optimum to ask for code. I did not do that.
Then, secondly, is, following that meeting, according to Mr. Efron, the interim arrangement is in place, in terms of which OCM will supply coal to Eskom at the Hendrina power station.
Yes.
And that's the interim arrangement I said, lived until 29 July 2016. But here on the hardship clause, Mr. Efron says, in early 2014, Eskom approached OCM to see if it would agree to suspend the hardship arbitration. So remember, 2013, they invoked the hardship. He says, early 2013, invoke, 2014, you, Eskom, come to them and say, suspend the hardship arbitration, because they've taken the matter to arbitration.
2014.
Early 2014. Allow for a period of negotiations regarding the hardship claim.
Well, he wasn't there in 2014. Eh?
Yes.
Yes, no, I accept that. I'm just telling you, because you were saying, why didn't they pursue the hardship clause? And the answer seems to be here. So Eskom says, suspend the hardship arbitration to allow for a period of negotiation regarding the hardship claim and other disputes. OCM agreed, and on 23 May 2014, they conclude the cooperation agreement, which providing a process to further negotiate potential amendments and an extension of the CSA, as well as possible settlement of disputes in relation to hardship and penalties. The hardship arbitration was suspended and certain interim arrangements were put in place to ameliorate the difficulties experienced by OCM. The parties also suspended the enforcement of their respective rights on account of alleged breaches of the CSA. So we know that this is the cooperation agreement which ultimately
In
gets...
2014.
Yeah, it's concluded 2014, suspends
Yeah.
the hardship.
But the
and so-
person who signed the cooperation agreement, Mr. Sile, did he have authority to do so?
I will come to that. All I'm saying to you is, this is how the hardship clause was dealt with. The parties agreed to suspend its enforcement, entering into that cooperation agreement. Number 3.
If I,
Okay, yes, please.
all right, the only way of dealing with the hardship clause would have been to go for arbitration.
Yes, that's why I'm reading to you what Mr. Efron is saying. They had invoked that.
What Mr. Efron said.
Yes, they had invoked that, and the parties agreed to suspend it, entering into a cooperation agreement to negotiate a new agreement. So they didn't sit on their loins and let the situation just run its course. And with the affidavit that has been referred to by the chairperson of Mr. Efron, he explains that the hardship is intended for the very purpose where circumstances change, that a party can then invoke a hardship clause in a long-term agreement to engage in negotiations for better or reasonable terms between the parties. I'm just giving you the version. I'm not saying this is what I'm saying, my view, yeah. So you can invoke it in the long-term agreement because you don't know what's going to happen 10 or 20 years down the line. Circumstances change, unforeseeable. You invoke the hardship, you then start negotiations because that's what the hardship clause triggers. It triggers negotiations to propose amendments to an existing agreement. So that's the explanation.
If I may comment.
Yes.
Well, it's the old story of the lion and the hunter. So it depends on who you believe about what happened at the hunt. You believe the lion or do you believe the hunter? That is his version.
So
And
which
here's
one
my
is the
version.
lion?
I don't know. I'm just making an example.
Okay.
That is his version, and I've got my version, and I'll stick to my version.
Yes. Except that his version, no, I don't think it's a version as such, as much as is a reference to the hardship clause to tell you when it gets to be triggered and what it triggers as a result of it being invoked. The parties then start to negotiate, and this is what you found happening at Eskom when you arrived.
See, Mr. Slege, in terms of the coal supply agreement,
Yes.
the only thing that the hardship triggered was arbitration. Not the fancy things that they started engaging
The negotiations?
in. Yes, no.
Well, maybe, Mr. Slager, I should say, is Mr. Efron,
Mr. Molefe needs to either pull the mic closer to him
Oh,
because
okay.
the sound system doesn't pick him up.
Sorry.
yeah, I think speak closer to it.
Yes.
Is Mr. Efron referring to the hardship clause to explain why they didn't do due diligence? In other words, is he saying that we didn't do due diligence is not a problem because there is this clause? We could always ask for negotiations, and if we were under suffering hardship, we could invoke this clause. Is that in part at least what he's saying? Or you are not sure?
Yeah, I don't want to put it at that level, Chair.
Yeah.
I know from his affidavit the direct reasons specific to why they didn't do due diligence are centered around what he says was publicly available information at the time, and them not or trying to avoid alerting third parties that they were about to take over OCM. Yeah, so publicly available information, and understood that it was competing with various other potential purchasers to acquire the control of OCH, and therefore took the strategic decision to rely on that publicly available information and effect its acquisition through a series of transactions with OCH on this stock exchange without involvement of OCH. Yeah.
So I'm trying to understand the significance of his point about the purpose of invoking the hardship clause, particularly because, as I understand the position, on this particular occasion, they didn't pursue it up to the end, namely arbitration, as I understand the position.
But yeah, Chair, just before you, Mr. Molefe, as he explains in these affidavits, and sorry, it doesn't answer your main question, but your ancillary question. The pursuit of the hardship clause was made. It was interrupted by the parties agreeing amicably to suspend it and enter into a cooperation agreement. Then, this is in May 2014. By the time of the termination of the cooperation agreement in June 2015, there was only a period of over a month before OCM went into business rescue. Then the business rescue practitioners take control. And that's when they start engaging with Eskom. So whether in that process they could, as OCM, still pursue the arbitration, they would, I think, have had to seek the consent of the business rescue practitioners would have had to run with it.
Well, so I'm trying to understand the point because they are aggrieved by the fact that they are aggrieved by the price that is in the contract. They want it to be increased. Eskom says no. They have the option of pursuing arbitration under the hardship clause. They initiate that. Then on what you have told me, by agreement between the parties, it's either terminated or suspended. Pending the outcome of the efforts that would be made under the cooperation agreement.
Right.
When Eskom terminates the cooperation agreement, obviously, they must go back to using the hardship clause and pursuing arbitration if they still feel aggrieved and they feel they have a case to put before the arbitrator. So that's what I'm trying to follow. And after the termination of the cooperation agreement, they didn't pursue the arbitration, as I understand it. Of course, you say 2 months' time they went into.
My recollection is that they did, but I'll have to check the specific paragraphs. That matters then went back to arbitration after the termination, because then Eskom also referred the penalty claim to arbitration. I think the two were then consolidated. Mr. Molefe, you will remind us.
But do they blame Eskom about anything concerning arbitration or arbitration not taking place? So in other words, what's the importance, significance of whether they followed or didn't follow or pursue up to the end the route of arbitration as far as they are concerned? Because as I understand it, nothing prevented them from pursuing arbitration, even when there was an agreement to suspend. They didn't have to agree to suspend the hardship clause or the route of arbitration if they didn't want to, and they wanted an arbitration award to be issued in their favor. So I'm trying to understand what their point is about the arbitration
Yes. No,
route.
they don't apportion any blame on Eskom in regard to I don't want to say the apparent failure to pursue the hardship clause to the very end. I think what one sees from the evidence, Jay, is that the situation gets overtaken by events. Because this arbitration is ultimately pursued beyond 2015, is then 2016, and 2017 gets to be settled on the penalties. By December 2015, there's an agreement to buy shares in OCH, to take over OCH. But I will have to see the passage regarding what happens immediately after the termination letter from Mr. Molefe, which I have found, by the way.
But remember the big picture
Yes.
as you do that. The big picture is, I think they suggest in their evidence that Eskom was being, I think, unfair on them, to say the least, by insisting on this price that was in the contract. Mr. Molefe has given reasons why they insisted on that price. He has said they made a threat of stopping the supply of coal. He has said that was a negotiating tactic. He understood it. He put a plan in place, he says, subject to what I think you said. It might not have been a month, but he says he had a plan how to deal with that threat if it materialized. So it's important to keep the big picture in terms of what we are trying to establish.
Yes. Yes.
I think Mr. Molefe has been dying to say something.
Yes.
Mr. Molefe?
Chairperson, there is something that was mentioned by Mr. Sleka that I think is quite fundamental and goes to the bona fides of Optimum. He says that they did not do due diligence because they were afraid of
That parties getting to know.
Confidentiality. Yeah. Now, in due diligence, the first thing that gets signed is confidentiality agreement. Very strict confidentiality agreement. The information gets put into what they call data rooms. I have in my life, Chairperson, done a lot of transactions that had very sensitive information. Confidentiality is never an excuse not to do due diligence in the first place. Secondly, the two things that sunk them was the international coal price. International coal price. That has got nothing to do with confidentiality. They were open to the international coal price. They did not hedge themselves. Number one. Number two, it was the 150 rand that they knew was in place. It was not a secret, it was in the CSA. You could have called Eskom, it would have told them that you have a price of 150 until 2008. They decided to pursue the transaction despite knowing that. And by the way, Chairperson, The 150 rand itself was the result of arbitration with the previous owner. So Eskom had gone to arbitration before on this very agreement. The reason they were not going to arbitration means that their bet was on something extraordinary.
So part of the point you are making is that OCM should not have been crying they were crying
Exactly.
about being treated unfairly by Eskom,
Exactly.
because in terms of the coal supply agreement that was in place, there was a hardship clause which they could use if they felt that Eskom was treating them harshly.
Yes,
And they could take it up to arbitration.
yes,
And you say they had done so before, and there was this 150 was as a result of arbitration. And they chose not to pursue the arbitration clause to its end.
yeah. To the point where I even felt like they were treating us like little boys that needed to be taught a lesson. That would not follow through on our rights in the agreement. They had a sense of entitlement. Chairperson. They had a sense of entitlement. There was proper mechanisms in the agreement to deal with the situation.
And you say if they felt that they had a good case to put before the arbitrator,
Yes,
they had the opportunity to do so.
yes,
Why didn't they do that?
yes,
Because the arbitrator would have had power to increase the price if they made a proper case.
yes, yes.
We are 2-3 minutes before 1 o'clock.
Yeah. Let me deal with this one, Chairperson. Then the notices by the DMR. Those notices were before OCM went into business rescue, because OCM, well, actually they coincide with the business rescue. On the 4th of August, 2015, these are notices in regard to OCM's alleged failure to follow a proper retrenchment process. These are different from notices of November 2015, which we will come to later. Because with the notices of August, 4 August 2015, Mr. Ramatlodi and Mr. Ramoncha say you did not meet with them. Those notices were then lifted on the 7th of August 2015.
Yeah, there were two meetings. When those notices were given to OCM,
Remember to come closer to the mic.
when those notices were given to OCM shortly after my meeting with Mr. Glazenberg, where I said he's putting a gun to my head. And I remember distinctly, Chairperson, thinking, how did they get to Mr. Ramatlodi, who is now executing their plan to stop supply? I did call Mr. Ramatlodi, we had a meeting, and I explained to him that, please, withdraw those notices because they are threatening the security of supply. We are in a very delicate negotiation. And shortly thereafter, they were withdrawn. I agree, there was another meeting later. But what is strange about the allegations of Mr. Ramatlodi was that we were saying in that meeting that he should withdraw Glencore's licenses. We could not have said he must withdraw Glencore's licenses. When he had already done so previously. He had already done so previously of his own accord for different reasons. And I specifically persuaded him, don't do this because you're complicating a very delicate. And immediately after, you can check the dates, immediately after those notices were withdrawn, and OCM was allowed to operate again. They then went into business rescue. And the day after business rescue was announced, they stopped supply. Their objective was to stop the supply of coal.
But, Mr. Molefe, to the extent that you are saying to me, you suspected that there may have been collusion between Minister Ramatloti and OCM with regard to the issuing of those notices. Why would OCM have needed to talk to him in order to stop coal? Because they could stop coal without his assistance.
No. Chairperson, I'm not saying that there was collusion.
What are you saying?
I'm saying, well, it was coincidental.
Yes.
That immediately after the threat was made, the notices were issued by DMR. What I'm saying is that it did cross my mind that they might have made contact with Mr. Ramatloti. I do not have evidence to that effect. In fact, it could be purely coincidental.
Yes.
Yes, it
But
could be
you
purely
accept-
coincidental. But it happened at a very interesting time, which is just after Mr. Glazenberg had put the proverbial gun to my head. And
But
I asked him to shoot.
you accept that to stop coal, they didn't need his assistance, OCM.
No, Chairperson. What happened is, they needed an excuse. Because when Mr. Glazenberg said we will stop the supply of coal, CDH can tell you, I immediately gave them instructions to interdict the stoppage of the supply of coal, right? Because we have a contractual agreement. They were obliged to continue supplying us at 150. So there had to be an extraordinary reason for the interdict not to succeed. So suddenly, it's the DMR that says, because of retrenchments, we're taking your licenses away. So you can't interdict that, because they will say, but it's not us, it's the DMR. Then that gets fixed, and then coal supply is restored. Then they go into business rescue, and you can't interdict business rescue. So the only thing legally that we could do when they stopped, if Mr. Glazenberg was to carry out this threat of stopping supply, was to interdict. But business rescue and DMR would not be interdicted.
But leaving out DMR and the issue of business rescue, ordinarily, if they wanted to stop supplying coal, they would not need anybody's assistance, ordinarily. Is that correct?
No, we would interdict them.
No. If you don't interdict them, if they don't go to anybody, if they want to stop, they could just stop it.
Yeah, they could stop it.
Yeah,
But
you would have your remedies.
We would come running to the courts, Chair, and
Yes,
say we
yes.
have an agreement with
Yes.
these people, and we would sue them.
Yes, yeah. But practically, they could stop it and fight you in court if they want to.
Yeah, they could stop
Yeah.
it and fight with us in court.
Yes, yeah.
But you see, I was getting ready for that battle.
Yes.
Yeah.
Yes.
Of interdicting them. But
Yeah.
then they got business rescue.
You think they dribbled you?
Yeah, it was hard, Chairperson.
Okay, all right. I think we must take the lunch break. Unless
Can
there was some...
can I clarify
Yeah,
something?
okay.
Yeah. Because on the facts, Chair, Mr. Molefe, the August notices are issued on the 4th of August. By that time, there's no stoppage of coal supply to Eskom. They had not
notices?
stopped. The DMR notices
Yes.
in regard to the retrenchment process are issued on the 4th and then lifted on the 7th of August. The business rescue practitioners only notify you on the 20th of August that they are going to stop.
Yes.
So their stoppage had nothing to do, and even assisted by the DMR.
The effect of the notices would eventually lead to stoppage of supply.
Yes, but supply didn't stop.
No, it didn't stop. I never
yes.
said it stopped. But the conditions were created to stop it.
Yes.
Yeah,
So-
but I think part of the point Mr. Slega is making is this, because I understood you to be saying in your evidence, the notices came after Mr. Glesenberg
Yes.
had spoken to you. I seem to understand that he is saying, no, the notices came first,
No.
because, or at least the business practitioners only came much later.
Chair, you may well be correct. Mr. Molefe hasn't given us a date
Yeah.
when he has met with Mr. Glassenberg.
Yes,
The
okay.
meeting we have on record is of the 3rd of September.
Yes.
That's way after those notices of August.
Yes,
But then that's where the two parties capitulate
yeah.
and they agree to enter into an interim arrangement from then going forward.
Mr. Glazenberg was not in the meeting of September.
Yes, no, I'm not saying he was.
No,
All I'm
what-
The
saying
meeting
is,
that Mr. Glazenberg was in
Yes.
was before the DMR notices, before business risk.
Do you remember the date?
It was sometime in July.
Sometime in
I
July.
can't remember the date. I can.
Yes, but
But
the-
there were people at that meeting. In fact, Mr. Ephron, in Mr. Ephron's affidavit, he may refer to that meeting. I'll find it during lunchtime, Jefferson. I'll look at,
Okay, all
even
right.
my affidavit, I may refer to the date in which we met Mr. Glazenberg from Mr. Ephron's evidence.
But you please do check during the date during the lunch break.
Yes, yes,
But we
yes.
might not need to spend too much time
yes,
on this issue, because you said you were not even suspecting, but something crossed your mind about the notices and the threat.
Yes.
So, but,
You must appreciate, Chair, that under these circumstances, you also become very paranoid.
yeah,
So when two things happen,
yeah.
you start joining dots that don't
Yes,
exist. Like
yeah,
people join dots.
yeah.
these days.
No, that's right. So when we come back, maybe Mr. Molefe can just indicate what date that meeting was, but we don't spend too much time on it. On it, we move on.
yes.
Okay, all right. Let's take the lunch break. It's now 1:08. We will resume at 2:10.
Thank you, Chair.
We adjourn.